If I were going to rename the next section, the Statement of Financial Affairs, I might call it trick questions, cross-examination. This is the most challenging part of your bankruptcy petition. And the problem with it is that when you go into most attorney offices, they're going to have you signing all these papers, and the Statement of Financial Affairs will always be towards the end of what you're signing. And it's all single-space, small print, and you're going to be intellectually tired at that point, and you're just going to sign it. Well, no, that's not the way to do it. You and I aren't going to do it that way. In my video series that I make available to clients, I've got an extensive section of the videos showing you what we need to do to properly and accurately answer these questions. Again, they're trick questions. You can read those questions as an intelligent person and miss what they're actually asking you. There are legal terms of art that are included in these questions, and that's not disclosed to you. The purpose of why they're asking the questions isn't disclosed. Now, if you'll watch the segment in this tutorial on competing interests, then you're going to have a great deal of understanding as to why they're asking you a number of these questions. I want you to understand those. Not because I think you've done anything wrong and we need to hide something, but, you know, understanding is a value in itself. So let's take a look at this. It's probably going to take us a couple videos to go through this. You and I, for a consumer bankruptcy, we're going to answer questions 1 to 18. And if you have been in business during any part of the 6 or 8 years before filing, we're going to complete questions 19 through 25. I always have to look whether it's 6 or 8 years. But let's look at some preliminary definitions that they give you. Those definitions are not in themselves sufficient, but they're a starting point. In business, well, what's in business mean? Well, here it is, 6 years. So if you've been in business during any part of the 6 years before we file, then we're going to complete questions 19 through 25, as well as questions 1 to 18. Well, in business, that's a broad scope, any kind of business that you've been in. Insider. Now, in the video series that I make available to clients, I go through the statutory sections, and there's a major part of the bankruptcy code that has a bunch of definitions that apply to the entire bankruptcy code. Well, insider is one of those terms that's defined. So I hope you become a client, and I hope I can share with you that video, because understanding those terms is essential to understanding bankruptcy. But an insider essentially is somebody that you would give a preference to if you could. If you're going to know that you've got some assets that aren't exempt, you'd probably give your assets away to an insider before you would to anyone else. That's the beginning point for understanding the word insider. However, if you read the legal opinions, they do not limit the meaning of insider to that statutory definition. They've expanded that so that it'll fit any circumstances they want to. So it's a real broad concept. But let's start off with question number 1. Essentially, what we're going to do is give you your year-to-date income. If we're filing in 2008, we're going to put how much you and your wife separately earned in calendar year 2007, the year before. So when you come in, bring me at least the cover sheet for your 2007 federal return, so I'll have that information to complete this question. I also need, when you come in, for you to bring me your 2008 federal and state return so I can complete the remainder of this question. I'll let you read the entirety of the question, but it's a income question, essentially. Income from other than employment or operation of a business. That's a question. Let's say that you painted your neighbor's house last summer. Well, you might not think of that as a business, but that's going to be included in the response to this question. So that's what I say. There's a lot of trick questions within the statement of affairs, and this is one of them. Where did the money come from? You know, how many houses did you paint? Did you sell stuff on eBay and make money? Did you advertise property that you owned in the local newspaper and sold it at a profit? All of that needs to be included in here. Now, what's the practical repercussions of you listing all that? Probably nothing. We just need to list it. You know that old saying, the truth shall set you free? Well, that's the way it is in answering these statement of affairs questions. Here's an individual, question number 3, payments to creditors. Anybody that you've paid $600 or more to within the 90 days before bankruptcy, you're going to list here. Well, you undoubtedly, if you're making mortgage or house payments, you've undoubtedly paid any one creditor more than $600 for rent or your mortgage payment. Your car payments, add up the total amount that you've paid to any one creditor. Let's say your home mortgage loan. Did you pay them more than $600 during the 90 days? If you did, then we're going to list them. They're not asking you, if you notice, did you make any payments to unsecured creditors? No, they're asking you for all payments to all creditors that you paid more than $600 to. If you watch the section on competing interests, that segment, you'll realize that the trustee isn't going to accept our representations about who is and who isn't a secured lender. He's going to want proof from you and the lender as to who is secured. And that's why they want to know about every payment more than $600, period. So we'll have to answer that question, and we'll undoubtedly use some continuation sheets to do it, but you and I are going to do it, and we're going to do it properly. Debtor whose debts are not primarily consumer debts, list each payment. So if you've made any payments that fit that category, we're going to list them. It may be that the trustee in bankruptcy for a business will ask one or more of those creditors that you paid for the money back so that it can be pro-rata distributed among all the creditors. Likewise, up on the question up above, on question 3A, let's say you did pay somebody more than $600 and they were an unsecured creditor. Well, if you'll watch the section on competing interests, you'll realize that there are possible consequences of you paying somebody in preference to your other unsecured creditors. So be sure to watch that sequence. All debtors made within 1 year to anybody that was an insider. So, you know, did you make any payments to a brother-in-law or a sister or your parents? Did you pay anybody that was an insider within the 1 year? Now, it may not have any consequence to you or to the relative that you paid the money to. That's part of what you need to review with me. If you paid them for an antecedent debt, something that you owed to them before, then that's a potential problem. If you got value right when you paid them, then there's no problem. Maybe you bought a car from your brother-in-law. Well, you know, you paid him, and he immediately and concurrently gave you the car. Well, there's no problem, but we need to disclose it. Number 4, list all lawsuits and garnishments, executions. You and I are going to list every creditor lawsuit that sued you. Well, I can find on the court dockets, the state court dockets, all of your lawsuits, so don't worry about that. But if you have a workman's compensation claim pending, if you have a divorce, you need to bring me a copy of your divorce decree and your separation agreement. The trustee is going to want to see that separation agreement. Why is he going to want to watch that? Well, he'll compare the assets that showed up in your divorce to the assets that we listed. And if there is a difference, which undoubtedly there will be, because you might not have gotten property that you should have gotten, or maybe you sold property, whatever, but it's a beginning point for his analysis or investigation into your assets. If you have a personal injury lawsuit, I want you to be sure and watch the segment on exemptions, because personal injury lawsuits are not protected under Missouri law. But whatever lawsuits you've got of any kind, we're going to list that within that question 4A response. List all property that's been garnished or attached. Now, if you've got wages that your employer is holding, subject to a garnishment, I can use the exemption laws to, in most cases, get that money back for you. But whether I can or can't get the money back, we're going to list all the garnishments that were taken out of your wages and bank account attachments during the 1 year prior to filing bankruptcy.